All right, folks, it's time for Cut to the Chase. I brought Mike Burns back, 3M. I know a lot of people heard about that bankruptcy and they're like, wow, I got a lot of time and resources into this. How can a company whose market cap is 80, I looked it up, for starting in August was $83.96 billion,
That's with a B.
making them the 156th most valuable company. What are they doing in bankruptcy court? And, I know that a lot of the people that I know that are sort of relying on me for information about this 3M mass tort, the largest mass tort ever, are like despondent, depressed. They're like, I'm getting pennies on the dollar. And I'm like, no, we are going to fight this. We've got the best lawyers and the best team. And this is, I'm sorry, I got to use more French. This is a bunch of bullshit. Okay. And this is not like a rubber stamp. They file for bankruptcy and that's bankruptcy court. No, these things get challenged. And Mike, we had hearings yesterday. We had hearings a couple of weeks ago. We're going to have a hearing next week. Try to make sense of this for me. All right. Talk to me.
Sure thing, Greg. Great to see you on Golden Pond here at Cut to the Chase. But we had a great day in front of Judge Rogers in Pensacola yesterday with Ashley Kellner arguing on behalf of the plaintiffs and Plaintiff Vale in that particular case. And really what's happening, there's a couple things going on. Like you said, we had a hearing yesterday in front of Judge Rogers in which 3M is basically saying, hey, we want to get out of in front of you, Judge Rogers, and we want to go down to Indianapolis and have our cake again in front of the bankruptcy court in front of Judge Graham. And we're basically saying that the jurisdiction lies with Judge Rogers in the district court. Judge Rogers has had this case and all these cases, over 230,000 cases in front of her, and she's ruled on hundreds of motions, whether they be Daubert motions on the science that can be used in this case, the legal motions, what laws apply in this particular case. She's heard the evidence in 16 trials with 19 different plaintiffs, and she's heard these cases, and she is the judge that these cases were appointed to by the multi-district litigation panel. They put all these cases in front of her. 3M's trying to snatch them out in front of her and put them up in front of a bankruptcy judge and say, hey, Judge Rogers made mistakes. This is out of control, what's going on down there in Pensacola. We need some reasoned minds in Indianapolis to come in here and save the day for 3M. And Judge Rogers, I believe, thinks that it's possible that this whole charade, this whole show that 3M is doing is some concocted fraud on behalf of 3M and Aearo. Because one of the questions that she asked them yesterday was, before July 25th, July 26th, when Aearo filed and entered into this funding agreement with 3M, was Aearo in any financial disarray? And the answer to that question was no. And so they enter into this agreement that they're going to accept the liability. And now all of a sudden they want to file bankruptcy, and 3M wants to tag along with them and say, we get the same protection as Aearo does. So it's like they created this whole situation. And now they want to run over here and say, save us in bankruptcy court so that we don't have to pay these claims. The plaintiff's lawyers in this particular case, led by Brian Ailstock, you were on a Zoom not too long ago with Brian, and he's not going to let it happen. We're not going to let it happen. We're going to fight for everything we have for all these soldiers that fought for our country and have given up their honor and sacrificed their hearing and have tinnitus and hearing loss, and we're going to protect their rights. And we're going to protect their Seventh Amendment right to trial by jury of their peers, which that's what 3M wants to get away from. They want to bring this case up into bankruptcy court where they don't have to be in front of a jury of their peers. And we're going to fight for those rights for these soldiers that served our country honorably in the Middle East and all over the world. And that's what we're going to continue to do, Greg.
All right. So let's take it a little bit piece by piece. We've already, this is probably about the 8th, 9th time I've had you on talking about 3M, the combat litigation, earplugs, and now all of a sudden we're talking about Aearo, Aearo Technologies.
Correct.
What is Aearo? I don't understand where they fit in the
So
equation here.
Aearo is a subsidiary of 3M. That's who 3M bought the combat arms earplugs from. They're the ones that, one of the companies that developed the earplugs. 3M, wanting to get into the military market, bought this company and back in the 2000s and took over the company. I want to say it may have been 2008 is when they took over the company. So at that point, they owned Aearo. They took over all of Aearo's assets and liabilities and all that. And then, of course, you know how this whole case came about. It came about a whistleblower. Somebody told that that these earplugs didn't work, and the Aearo and 3M knew that they didn't work. And 3M entered into an agreement with the U.S. government, the U.S. military, the DOD. It's called a key tam case, where they admitted that they committed a fraud on the U.S. government. And at that time, 3M wrote a check to the U.S. government for $9.1 million, not Aearo, but 3M. And so now 3M's coming back and saying, oh, well, you know, it's really Aearo's the one that's liable for this and not us. We may have written the check, but it's not us that was responsible for it. They put up an argument yesterday in court, Greg. You would have fallen out of your seat. You would have laughed. Judge Rogers laughed. I guarantee you, she laughed. She said, excuse me for laughing, saying that Aearo is 80% responsible for the damages and 3M's only 20% responsible for the damages. And Judge Rogers said to them, when did anybody tell me this? You've been in front of me for 3.5 years. Nobody's ever brought this up until today. And so it took Judge Rogers, caught her off guard, but at the same time, she's going to be prepared. And I expect her to issue a ruling in this particular case before the week's out, or before the bankruptcy case starts again for a permanent injunction on Monday at 8:30 in front of Judge Graham in Indianapolis.
Okay, I think it's a preliminary injunction. That's the first.
It is a preliminary injunction.
Okay, which from what I understand, I know both of us are not bankruptcy attorneys, and we always say, oh, we're not bankruptcy attorneys, but blah, blah, blah.
I think
blah,
I said permanent, and I apologize. I used the wrong.
No. It's just tons of information. So that's why I'm here. I'm like the catcher, you know, I'm like, you know, maybe once in a while you throw a wild pitch and I'm like, I got to scoop it up and hope it doesn't hit me in the whatever. All right. So Aearo, 3M, there's no dispute. 3M buys Aearo, their assets and liabilities in 2008. There's no
Correct.
disputing that.
None.
And one of these liabilities are all these cases.
Correct.
That's what a liability is. All right. It's an unliquidated liability, except for the 13 veterans who've actually won at trial. Those are, you know, even though they're getting appealed, they're essentially liquidated. There was a number there, right? So now
Correct.
Aearo is the one that files for bankruptcy protection.
That's
3M
correct.
does not.
You're right. All the way. Everything's right that you said.
Okay. So just basic bankruptcy law, you file for bankruptcy protection, there's an automatic stay. People can challenge the bankruptcy. It's a fraud on the court. It's a this or that, but all the litigation stops except for the bankruptcy proceedings. That would be related to Aearo. How is 3M? All these cases are filed against 3M. How does one thing have to do with the other?
Well, 3M is.
How are they trying to make it?
Well,
today?
So what's happening is the judge did not issue the automatic stay in the bankruptcy, which normally happens, but he did not do that. And so he didn't issue it, TRO, the temporary restriction. And so we moved to Monday this week coming up. And you make the great point. How does 3M get the protection of the bankruptcy when 3M did not file for bankruptcy? And they're claiming that they should get the protection because Aearo is a subsidiary of theirs. They entered into this funding agreement to fund the estate, and therefore they are harmed if the cases are allowed to go forward in front of Judge Rogers in the district court. The estate would be harmed that Aearo represents, because they are the ones that have agreed to basically fund the case with with Aearo. So they should get the protection. Judge Rogers is not buying that argument. I don't know if the bankruptcy court is going to buy that argument. Why should 3M, a non-debtor, get bankruptcy protection because they did not file? And then back to your point about, was it fraudulent? Is this a fraudulent transaction? That'll be litigated in front of the, it could be litigated in front of the bankruptcy court. But I expect both Judge Rogers and Judge Graham to issue rulings late this week, next week, in both cases. And at the same time, the multi-district litigation panel may issue a ruling in their particular case and send the case to Judge Rogers, the bankruptcy case, and keep everything in front of Judge Rogers.
Okay, and so that's what we're getting, like, hyper technical on the law. There's like 3 different courts basically addressing different issues. Who's going to be handling the bankruptcy? Is it Judge Rogers? Is it going back to the Northern District? There could be a bankruptcy judge there. Right now, the bankruptcy petition was filed in Indiana?
Indianapolis, yes, Indiana, yes, in front of Judge Graham.
And so it's in front of Judge Grant, and he's the one that's going to conduct basically it's like a little mini trial starting Monday on whether they're going to do a temporary, a preliminary injunction.
Correct, and we're going to be heard in that case. Brian Ailstock is going up, and we have many of the plaintiffs' counsel represented in that particular case, and present our case in front of Judge Graham, who was appointed by President Obama, I believe, in 2014 to the bankruptcy bench.
All right. So when we talk preliminary injunction, what is that? What exactly would that do?
Well,
if Aearo and 3M kind of win this particular battle,
it may stay the proceedings. It may stay the proceedings and allow them to reorganize, get everything situated in bankruptcy court. Let the creditors make their claims in bankruptcy court. It may allow the cases to be funded and settled in bankruptcy court. That's the big issue. You know, it may allow the bankruptcy court to set the values on the cases, which, you know, that's one of the issues that the plaintiffs take objection to. That Judge Rogers would be the one most appropriate to do that, since Judge Rogers has had this case for 3.5 years. She knows the cases, she knows the law, and that she would be the one most appropriate to handle that. So there's a lot of moving parts. You know, if somebody tells you they know what's going to happen, well, they're guessing. But there are a lot of moving parts. We're just going to have to stay tuned, fight the best battle that we can, and look forward to both Judge Rogers' ruling, Judge Graham's ruling, and possibly a ruling by the JPM out in the upcoming weeks and days.
So all right, so let me just go to 3M.
Sure.
3M is not filed for bankruptcy.
That is correct.
Aearo has filed for bankruptcy, and from what I gather, there's, you know, that bankruptcy, they're entitled to file for bankruptcy and get their stay and proceed, you know, under the bankruptcy code. They're asking the court to also stop the litigation as it pertains to 3M. The reality is 3M could file for bankruptcy protection, even though they, you know, have more money than, you know, most third world nations put together. But they're not. And, you know, I've actually personally had an experience where a company that was publicly traded that I own stock in, they went bankrupt. And guess what happens when they go bankrupt? They can't pay their shareholders dividends. They can't do stock buybacks. So
right.
My guess is that 3M, the last thing they want to do to try to stay, you know, correct all these problems with this litigation is file for that bankruptcy, because they would not hear the end of it from their shareholders. I didn't research how many shareholders.
You're absolutely correct. Yes, you're absolutely
what's
correct.
going on.
Right.
All right.
Is it a shell game? Is it a fraudulent transaction? All those things are going to be played out in the upcoming weeks.
All right. So now what I've heard is that Aearo files for bankruptcy protection. They've got to file an informational brief, basically explaining what their position is. And from what I gather, they're not even making bankruptcy arguments. They're actually attacking the judge, not saying that her rulings were wrong, but like actually attacking her.
That is correct, Greg, and that was one of the arguments that Ashley Keller um, put forth yesterday in the motion in front of Judge Rogers, saying that there are times that you may disagree with the judge, and there are times that you may say things to a colleague about a jurist, or something that you may think about a judge. But to put those things in writing and file those things in a court pleading is a whole nother story that you or myself would never do, and has been done by Aearo or /3M in this particular case, in the bankruptcy case, attacking the judge and her handling of the MDL that has been in front of her for over 3.5 years.
And two of the things that, from what I understand, from what I'm hearing, because I just got off the webinar with Brian Ailstock, Brian Barr, and I've been researching this and all that, is in addition to attacking the judge, and not just her rulings, but some of the rulings that they're attacking are procedural things that they actually asked for.
That is correct.
The administrative docket and, the TUI procedure and all that. Explain what those things were, and how this is how they've like decided, oh, this is what we wanted, they got it, and now they're like complaining about it.
Right. So the administrative docket came out of an agreement so that 3M could get their arms around the litigation, and there was what a lot of us call a tolling agreement, which stops the statute of litigations running, and you give the defendant a list of all your cases, or a list of all your clients, and the statutes toll against them. So then it basically stops the clock running, so they can file their lawsuit or whatever in their particular case. But it allows the defendant in this case to get their arms around it, know how many cases they were. Well, Judge Rogers came up with the administrative docket because she wanted to have jurisdiction over the cases. She felt like she did not have jurisdiction over the cases if they were on a tolling agreement. But if the cases had been filed some way with the court, then the court had jurisdiction over those plaintiffs, as well as the defendant. And therefore, if there was a settlement agreement or of some sort, then she could enforce that against all of those individuals that were on the administrative docket. 3M agreed to that, and they agreed to that particular process. And then the next step was what you said, is the TUI request. TUI was a guy that filed a lot of cases against the FBI back in the day. And so when he made all these requests, that's how it became known as the TUI request. That's requests for documents from the government. And so what we had to do is, in order to get the records in this case, the records had to come from the Department of Defense or the VA in this particular case. You had to make a TUI request. And that TUI request was a discovery request to get the information, the medical records for your client, where he or she may have served, who may have seen them, the audiologists, the ENTs. That's what the TUI request was. Both of these things, the administrative docket and the TUI request, were agreed by the parties, the plaintiffs and 3M. And now they're acting like, hey, we want a do-over on all of this.
So going back to, the reality of 3M and their market cap and all their shareholders in this administrative docket, from what I understand, is if all these cases are actually filed in court like a regular, lawsuit, and then you don't have to worry about the statute of limitations as long as you filed it on time, they have to actually put that on their balance sheet. So if they say, we have all these assets, we have all these liabilities, our company is valued at X number of dollars, which makes it a more attractive stock to buy. If they have all these lawsuits on, that are actually filed, it kills the stock.
And that's exactly what they didn't want to do.
Yeah. So they
exactly
wanted their
what-
cake and now they're, I don't know, there's some phrase that goes along with it. All right. So now, all right, 3.5 years, Aearo Technology, they don't file, are they involved in the litigation? Are they a named party?
Yes, they are named. They are named defendant in this particular case. And so what happens? So when you're referring to the case before the jury, it's all 3M, and all of these subsidiaries are listed in the complaint, but they're all referred to as 3M. And during the trials, 3M has agreed to that.
That's right. And so when the Aearo doesn't have their own lawyers,
That's correct.
it's 3M. So 3M goes
3M
up.
represents 3M represents everybody. Yes,
They go
correct.
and they make their opening argument, their closing argument, and they say, on behalf of 3M, we didn't do anything wrong, blah, blah, blah. They're not saying, hey, there's this Aearo and they're really the one to blame and don't point the finger at us. We had nothing to do with it, you know. This was
That's
right.
correct. They're saying we didn't do anything wrong, is what they're saying.
Okay. So now, yeah, all these 19 trial, the bellwether process, I'm just taking a couple steps backwards.
Sure.
The Judge Rogers actually, from what I understand, ordered mediation, and there was 3 days in New York where a mediator was appointed. They tried to mediate, and from what I understand, I know it's confidential, but from what I understand, it was a sham. The whole thing was not done in good faith.
Well, I mean, that's the way that's our position, and I think that's what's going to play out. Is because it wasn't shortly after that. The next thing they know is 3M/Aearo files bankruptcy in front of Judge Graham in Indianapolis. So the mediation or settlements talks began. I believe it was July 15th. It may have been July 15th, 16th, and 17th. And then within 10 days or less than 10 days, they've filed all this in front of Judge Graham in Indianapolis in the Southern District of Indiana.
All right. And so one of the complaints from 3M, you know, they're attacking the judge, they're attacking the judge's rulings, they're attacking the mass tort multi-district litigation process, which is designed to make one judge make all the rulings, so you don't have one judge ruling X, one judge ruling Y on preliminary matters or what things are admissible and all these kind of things, the government contractor defense. So from what I understand is that when you talk about the TUI requests, I don't know if there are lawyers that are going to be listening and they've had cases where they've tried to get records from the VA or the department. There's no way you cannot get records. And what I learned actually from Brian Elsock in his webinar was that the judge actually had to fly out 3 times to meet with the VA reps and the Department of Defense reps to like say, hey, listen, you got to turn over these records so, you know, people can make their claims and we can move forward with the litigation. That was startling to me that a judge actually had to go to that length.
That's exactly what happened. And I was involved in that process. Brian was involved in that process. We were in DC. The judge, I believe, went up there 3 times. I know myself, I was involved in it in one trip to DC with the Department of Defense and the VA with their lawyers in those meetings, negotiating with them on the production of these records. And that's what's so astonishing is Judge Rogers was intimately involved in the negotiating process with the Department of Defense, with the VA in obtaining these records and setting up this process to obtain these records, to streamline the process and to move these cases forward for both the plaintiffs and the defendants in this particular case. Because you know, Greg, it's very hard, whether it's a car wreck case or a slip and fall, to try and go forward with the case when you don't have the medical records. You can't prove the injuries. And Judge Rogers was instrumental in making sure that we got the records for these plaintiffs in order to move this litigation forward. And 3M was a participant in that process as well as the plaintiffs, but it was spearheaded by Judge Rogers.
And not only was 3M a participant, but when we go back to the ridiculousness of their arguments here now. You know, one of 3M's big arguments is that, oh, there's all these unvetted cases and claims. Well, from what I understand, Judge Rogers actually has dismissed tens of thousands of cases for what? Because there were no medical records to establish the injury. What, I mean,
That's exactly right, Greg. She gave us time limits, and then we did not produce those records. She told us that we had to produce the DD-214s, which are the records, the service records of the service member. We had to produce the VA records. We had to produce the DOD records. If we didn't, some of the cases she dismissed without prejudice, but a huge block of the cases she dismissed with prejudice, that those cases cannot be filed again because the records were not produced in accordance with her orders. So, you know, there was equity on both sides. You know, she didn't let the plaintiffs go forward, and she prevented these cases being filed against the defendant 3M and Aearo, because without the records, they couldn't defend the cases, and Judge Rogers would not allow the cases to be prosecuted without the records. So, you know, she has wielded the sword fairly on both sides in that sense, and used it very precisely to she's given each side opportunities, and if you do not meet those opportunities, she's been very fair and just in the way that she's administered justice in this particular case. And she's done it from the very beginning of this case, and all the parties have been involved in the process.
all right. So I'm looking through my notes here. That's why I'm looking down. You know, I mean, I took so many notes. The webinar just ended an hour ago. I had all these notes beforehand. So I'm going to ask you, after the preliminary injunction motion next week, will you come on again and give us an update?
Sure, be glad to, Greg.
All right, listen, because I got all these other questions here, but I want to get it a little better organized. Right now, folks, the be all and end all is this, from what I gather, is just a negotiating tactic by 3M. They're throwing everything. They first decided, let's see what the juries will come back with. If they're ruling in our favor, great. If not, then we're going to try another tactic. We're going to file for bankruptcy. We're going to take this shell corporation, Aearo Technologies, and let them do it. And we're not going to, you know, get dirty our hands and offend our shareholders. I mean, it's a perversion at the highest degree of magnitude. I'm expecting that the judge is going to issue a preliminary injunction. I'm just going to guess that that's going to happen, but it's going to be short, and that's not going to be the end of the ball game. That's not going to be like, oh, I'm getting pennies on the dollar. That's a preliminary injunction, not a permanent one. And, you know, we'll see how that's shaped. Maybe the judge is going to say, you know what, if I'm going to give this kind of protection to you, 3M, you can't issue dividends. You can't do stock buybacks. You can't act like you're, you know, operating and active like a, you know, a regular corporation. You want to play this game, you're going to have to play the game the whole way. That's what I predict is going to happen. But we'll see. You're going to tell us next week.
We'll see next week. That's for sure, Greg. And all our eyes will be peeled, and we'll be listening to us. It starts Monday morning, 8:30 in front of Judge Graham in Indianapolis, Eastern Standard Time. So
all right.
We'll be
so listen,
later next week.
Okay. So now I got to get this produced up, ready to go, so everybody can get the info, whatever. And then maybe next week I'm going to try to advance my production skills, and I'm going to try to do a live YouTube podcast with you. All right. You know, so, you know, we're going to cut to the chase. That's all I can tell you. All right, Michael, thank you for coming on and sharing your information, and we'll do this next week. All right. God willing.
Okay, Greg. Great being with you. Enjoy your time on Golden Pond.
All right. You got it, my man. Take care, everybody, and we'll be back soon.